Welcome, everyone, to the University of New Mexico Law and Mental Health series. This is a weekly discussion of practice and science by experts in behavioral health and the law, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico in the Department of Psychiatry and Behavioral Sciences. For our talk today, if you have any questions for our presenters, the Q&A box is your friend there. Make sure you enter your questions there anytime you feel comfortable. We do hold questions until the end. We try to get to as many as we can, but just forgive us if we don't get to yours. Sometimes it's just not possible to get to all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly, so keep your eye on the chat box. And for those of you that are pursuing APA continuing education credits, you will also keep an eye out on the chat box, but in the later portions of the talk. In the later portions of the talk, there will be a link in the chat box to a survey that you would complete. After you complete that survey, you would get your certificate for CEU credits. If for whatever reason the link isn't working for you at that time, make sure you copy it and put it in a safe place so that you can try again later on. And make sure that you save your certificate after you complete those surveys. We don't have access to those after the fact. The recording and PowerPoint slides for this talk should be available sometime later this week. And as a heads up for next week's talks in the series, we have Dr. Chris Lloyd, who will be discussing issues in forensic supervision. But for this week, I'm really excited to introduce you to today's speakers who will be discussing ethical and practical considerations in giving feedback in forensic mental health evaluations. This is Dr. Lizzie Foster and Dr. Sharon Kelley. Dr. Lizzie Foster received her Ph.D. in clinical psychology with a specialty in forensics from Drexel University. She's currently an associate professor of psychology in the Institute for Graduate Clinical Psychology at Widener University, where she teaches courses in forensic psychology, general assessment, and cognitive behavioral therapy. She also currently works at a private practice where she provides therapy and assessment services. Her areas of professional interest include forensic mental health assessment, juror decision-making, and experiences of mental health professionals in correctional environments. Dr. Sharon Kelley is a licensed psychologist and assistant professor of psychiatry and neurobehavioral sciences at the University of Virginia School of Medicine. At UVA, she works at the Institute of Law, Psychiatry, and Public Policy, where she performs forensic evaluations with youth and adults on a range of psycholegal issues and also conducts psycholegal research. Her clinical and research interests include practice of forensic mental health assessment, youth and adults' capacity to waive Miranda rights and enter guilty pleas, interrogations and disputed confessions, and police interactions with individuals with mental illness. Dr. Kelley, Dr. Foster, Sharon, Lizzie, on behalf of the University of New Mexico, we're excited to have you joining this series and thankful for you sharing your expertise with us today. I will go ahead and throw it over to you.
Okay, well, thank you so much for those lovely introductions. As you heard from Dr. Perillo, I'm Sharon Kelley. I'll be presenting today with Lizzie Foster. We are definitely in the first name kind of professional tone here. So let me get through some of the preliminary slides here so that we can talk about what we're actually talking about today. There we go. No need to belabor our bios. You just heard about them. You will hear a little bit more. We intersected both in graduate school and then again when I was on internship and Lizzie was a postdoc, and that's how a lot of this research began. But I'll let her tell that story in just a couple of minutes here. You heard about the CEs and the process for those. We have no financial arrangements at all to disclose here. This has been a labor of love and interest. And the views expressed here are ours and not the University of New Mexico. So our learning objectives in thinking about this talk for you all is really kind of ethics and practice based. So these are very much grounded in the APA ethics code and the specialty guidelines, thinking about the ethical standards that do apply to feedback and assessment generally, the guidelines that might apply in forensic mental health assessment specifically, and then how to address, the gaps that inherently exist when we're in the practice of forensic mental health assessment. And so how do we go about applying the guidance that we do have to kind of these challenging practice scenarios when they do come up?
So thank you.
Yeah. Go ahead.
Thanks, Sharon. Thanks for starting us off. And I'm going to just jump right in and tell you about how all of this began for us. And it really, Sharon and I were talking about it, began now over a decade ago when I was on postdoc and Sharon was on an internship, and I was just learning about forensic assessments and how to do them. And I think many of those early experiences become quite pivotal for your development. For me, it began with a case where I did a competence to stand trial evaluation and a civil commitment evaluation on an individual who I later had to testify about. And for this particular individual, his entire treatment team, the forensic team as well, felt that there was no question that commitment should be pursued for him. In the midst of my testimony, however, this man became really quite animated, upset. We had to stop my testimony on a number of occasions. Now, this had happened to me before when testifying, but this was the first time where I saw it happen, where the psychiatrist testified as well. And during her testimony, the defendant did not become upset. He did not start yelling out. He did not interrupt the proceedings. And after it was over, in fact, he came up to me really upset and had to be blocked by security. And all I could think as a young trainee, what had I done wrong? I felt I must have done something wrong. And I spent a lot of time thinking about it and realized that the psychiatrist who had testified was also part of his treatment team. And as a result, had had this conversation with him over and over again about his risk-related criteria. And so he was well aware about what she was going to say, but had no idea about what I was going to say when I testified. So I spent a lot of time thinking about this. And at our mini grand rounds, I presented on it because I thought someone must have an answer on my postdoc. This is a well-established forensic training postdoc site with strong interns like Sharon. And I presented on it saying, should I have given him feedback? Should I have let him know ahead of time about what I was going to testify on? And to my surprise, nobody had the answer for me. In fact, there were a lot of varying opinions about what I should have done, what I could have done, and people going through the ethics code and trying to figure it out. And I realized I had never been really trained in whether or not and how I should give feedback in forensic settings. And this made me do a deep dive into trying to figure it out. Sharon, would you have anything? Sharon was there at that initial grand rounds. Would you have anything to add to that, Sharon?
Yeah, it was a really dynamic conversation with a lot of people expressing very divergent practices and opinions, I think, about this issue. And of course, as a trainee, that's always interesting to see. But it felt like, oh, there's a lot to learn and a lot to explore when we have just a room of really bright, experienced people expressing really divergent opinions on this topic. And so we certainly didn't leave that meeting with kind of an answer, which is, maybe no surprise, but not even really a consensus or a convergence. So I think that's in part what piqued our interest in this particular area.
And I would add that actually I was surprised. As a trainee, I thought everyone else should have the answers to this, and I had done something wrong. So it was a surprise to me that there wasn't a consensus, as Sharon mentioned, about what I should have done or what should we be doing. So Sharon, do you mind moving on to the next slide?
Yes.
So here were our questions that we're actually going to try to set out to answer for you all today, which is the first is, can we even give feedback in forensic evaluations to the evaluee? Our graduate training didn't, well, strong and we loved it, didn't really provide us a lot of data about this. And our internship, very little, at least in my opinion. I learned how to give some feedback about malingering, but that was inpatient, and really postdoc, none for me. So this was really what we set out to answer in our research behind this and what we hope to talk with you about today. And then if we can give feedback, which clearly there's a presentation on this, so we have decided that you can, the question then becomes about how do we decide whether feedback is acceptable or appropriate to give directly, again, to an evaluee in a forensic evaluation. Okay.
So we first really, I think it is worth spending a moment of time on who cares, why even consider this topic at all, right? Like why, if you are a forensic practitioner who primarily or solely does forensic mental health assessment, why come to this presentation other than maybe the ethics CEUs? but it's worth maybe again spending a moment on both for practice reasons and for ethical reasons. So in tracing kind of the history around feedback generally, so this is not specific to forensic work or forensic evaluations, it's pretty clear that feedback was generally discouraged in early psychological literature. So this is maybe dating back to the 50s and the 60s. The kind of era of paternalism operated really strongly. And so it just really wasn't thought about, and to the extent it was thought about, most of the scholarship around this discouraged the practice. And really that only began to change in recognition of clients' legal rights to their medical records. And this kind of spurred a cultural movement, right, about balancing this power differential between professionals and clients. Some of the nomenclature starts to change from patient to client, although that's, we know not standardized. And the American Psychological Association first incorporated testing feedback into the ethics code in the early 90s in 1992. And then over the 90s, late 80s into the 90s and beyond, we see feedback increasingly seen as a type of therapeutic intervention and therapeutic assessment. And we know, right, maybe this leaves you still saying, well, I'm a forensic clinician, I do evaluations. Evaluations are really distinct from intervention work. That distinction is of great importance, right, in forensic mental health assessment. And so why would clinicians like us really care about this topic? There's some research-related reasons related to individuals' well-being, engagement in treatment, and their treatment outcomes. But then also, right, in kind of scanning our own experience and talking with colleagues and looking at the literature, we also know that practically speaking, we can use feedback to elicit useful information in an evaluation, move an evaluation along if somebody becomes a little bit stuck, right? Phrases like, I can see that you seem to be working really hard on this, but I can't give you feedback now. We have to kind of keep going. And as Lizzie mentioned, right, this issue of response style and malingering, right? Sometimes giving some feedback about the person's presentation to the person, right, might give them an opportunity to change it, might give you an opportunity to get far more useful evaluation or information for your evaluation. And then, of course, there's this kind of broader issue of when we're in a gray area ethically, and we'll talk more about that. To what extent should we be guided by some of those larger aspirational principles in the APA ethics code, right? Things like respect for the rights and dignity of our evaluees, who often are incredibly vulnerable with us during these evaluations and have some real problems, right? Whether it's a pure psychological illness or just difficulties in living, right, where feedback might be helpful. And so how do we kind of balance those aspirational principles against other obligations and duties that we have as forensic practitioners? So we decided this merited some research, some digging beyond the conversation at this kind of mini grand rounds. So we went, first place, right, is we go to the law. I don't have any other slides on the law, right, because perhaps no surprise, there's really no set of laws out there that are really going to address this topic for the most part. And our little asterisk or caveat to that is there will sometimes be contracts for certain types of evaluations, commonly independent medical evaluations, child custody evaluations. And sometimes in our experience and in others, we know those contracts will explicitly prohibit, right, the evaluator from giving any feedback to the person or people they are evaluating. But really with this exception, the law we found is unlikely to give really clear guidance on this feedback issue. So, on the one hand, we are confident that we have not set eyes on every single law in this country pertaining to every single type of evaluation. But based on the reviews that we have done of statutes, regulations, contracts, court orders, the law is unlikely to provide much guidance here. So of course, we next go right to sources of ethical guidance. And so the first place we stop is this, and this should say ethics code on it, right? These aren't the guidelines. These are actual, this is part of the code of conduct. And so section 9.10 here talks about explaining assessment results, right? And so we know from the standard that the basic duty on psychologists is to take reasonable steps to ensure that the explanation of results are given to the individual or designated representative, right? That's kind of our baseline and our starting point. Now, the ethics code does contemplate, right, this kind of unique position we might be in as forensic psychologists or forensic mental health practitioners, where the nature of the relationship might preclude, right, giving somebody feedback. And they basically say that's all right, as long as that's been clearly explained to the person being assessed in advance, right? So this sparked some questions, right, about our notification of purpose process, our consent process, if we're adequately addressing this piece of it. But certainly, right, the APA ethics code is giving forensic practitioners a bit of an out here. So we thought, okay, this doesn't really tell us maybe the how and the when or the parameters, like when exactly does the nature of the relationship preclude feedback, but we know it might be in this work. Our next stop, of course, is the specialty guidelines for forensic psychology. If you review those guidelines, you might be somewhat surprised. I think we were somewhat surprised to see very, very, very similar language to standard 9.10 in the APA ethics code. So the starting place of the specialty guidelines is that forensic practitioners take reasonable steps to explain assessment results to the examinee, right? That's, again, like where the guideline begins is kind of with a default assumption that we will be providing some feedback. Now, if you continue to read, of course, it goes on to say in which communication, in circumstances in which communication about assessment results is precluded, the practitioner is supposed to explain this to the examinee in advance. So really the same basic setup as section 9.10 of the ethics code, a baseline assumption that you will be providing feedback, some exception, right, based on this idea of preclusion, either based on the nature of the relationship we have with the examinee, or maybe circumstances that prevent us from giving feedback to the examinee. And of course, if we're not going to do it, we should be telling the person in advance. So in a way, this really puts the onus on us to be a bit more proactive in our thinking about feedback and not just wait until we get asked to provide feedback by evaluees. We, of course, looked to other sources of guidance as well. Again, I can't absolutely promise that our eyes touched, every page of every treatise and every journal article, but gosh, I mean, it was a struggle to find anything that talked about feedback at all. We did, this is like the right montage of Lizzie and I, like in a library reading all of these books overnight. We did finally find a footnote. We found a footnote in Heilbrun's Principles of Forensic Mental Health Assessment, where he says, the ethical demand and therapeutic assessment for an explanation of results after completion of the evaluation does not necessarily apply in forensic assessment. So this really doesn't go much further or further at all beyond what we already have in the specialty guidelines. We don't know when it might be recluded. We don't know how to make those determinations, right? We just know that there's this flexibility built into forensic practice that makes a lot of sense, but navigating that particular flexibility in the gray area here in our ethics, we don't have a lot of guidance on.
So we decided to try to do a little bit of figuring that out ourselves. Since we couldn't find it from the ethics code, we couldn't find it from previous literature, we decided to try to make it up ourselves. And so we did a very pilot, unsophisticated survey of professionals using the American Psychology and Law Society network, and created a survey that just asked questions along this feedback theme. So we Sharon, would you mind running to the next slide? Thanks. So we published an article in 2019 on our results of this survey, which essentially if you were to read this article, it just kind of gives that background that Sharon just provided in a little bit more of a comprehensive way, and also provides data about the survey we did of about 146 professionals. It was 126 professionals in forensic psychology who were members of APLS, along with about 120 and about 26 graduate students as well participated. So some of our analyses, we looked at them all together. Some of them, we separated them out, and both of those analyses were kind of interesting because overall what we found is that in the notification of purpose, the vast majority of individuals were not including specific language to tell the evaluee that they were not going to provide feedback to them at the end of this evaluation. But to me, the more interesting finding was about a third of participants. We asked a question along the lines of, basically, do you know whether or not you can provide feedback to an evaluee, if you should, if you're ethically or legally permitted or ethically or legally prohibited from doing so, just kind of to get a sense of if people had strong ideas about what the ethics code, what the law said, or if they knew what to do. And a third of people across the board said they didn't know, which left at least me and Sharon realizing, and our colleague Stephanie Holliday, that people just were doing probably what they had been trained to do and not thinking pretty deeply about it, or perhaps they were thinking deeply about it, but just weren't sure about what they were supposed to be doing at this point. And so soon, Sharon, anything to add about that research that we did back?
I don't think so, other than, just kind of reinforce the idea that, again, there wasn't really not that we would get a completely consensus view of the field from, surveying 100 like very dutiful members of the American Psychology Law Society who are maybe even more prone to thinking deeply about issues in forensic practice. So we knew there was maybe no consensus to be had, but even among the participants and even among the results we do have for our, participant pool, people were all over the place, right? It was just really unclear to folks how to respond. We got a wide variety of just kind of open-ended responses about how people react and reply or don't reply when evaluees do request feedback.
Yeah. And so soon after we published our manuscript, there was a manuscript by Brodsky that also touched on feedback. Yeah.
Oh yeah, this is me. Sorry, everybody. We do this little back and forth dance that's not as natural on Zoom. So like Lizzie said, Brodsky and Goldenson published an article, I think 2 years later. And this is a really lovely article, by the way. So the way they talk about feedback, they kind of go through many of the same kind of preliminary considerations that we have. And they talk about feedback along these three different levels, right? So one level, or level one, is going to be interpersonal or behavioral feedback, like your attention seems to be drifting, right? Kind of basic things that probably many of us do in our day-to-day practice as evaluators. The second level is interpretive feedback, right? So maybe raising hypotheses like that accident seemed to be a turning point for you is one of their examples. Or I wonder if there are times today that you might be presenting as more ill than you actually are, right? Going back to this theme about giving feedback about response styles and maybe giving the evaluee an opportunity to change. The third level is probative feedback, right? So feedback about the psycholegal issue, fundamentally. They review basically the pros and cons, right, of providing these different levels of feedback. And notably when, right, they get to that third level, probative feedback about the psycholegal issue, they conclude, right, this is likely going to be premature and overreaching. It could interfere with the legal process. So to the extent we have pros and cons of feedback, maybe writ large, they came out, right, reasonably so, we think, as kind of raising a lot of concerns and not so many benefits or strengths to providing feedback about the psycholegal issue. And I should note, we usually say this earlier on in our presentations on this topic, right? But we have been talking about feedback broadly, when we know that feedback comes in different forms, right? It's really different if somebody says to you at the end of an evaluation, what do you think, doc? Am I crazy, right? Like that's a question I've heard several times. That's different compared to testing feedback. And those both are different from, hey, do you think I'm competent to stand trial? Do you think I'm going to meet criteria for the insanity defense? So the Brodsky and Goldenson framework starts to approach this or does approach it. And then our framework for thinking about feedback approaches this as well. But just wanted to say out loud that we are cognizant that feedback can be a lot of different things in an evaluation, and your response might be different depending on the type of feedback that's on the table.
I appreciate that addition, Sharon. I'll just add to that. Our focus tends to start with the psycholegal question and whether or not you can provide feedback directly to the evaluee about the psycholegal question. But I think one of our arguments here is if you decide you cannot, what are other areas in which you can or should provide feedback to the evaluee on? So those are all pieces that we're thinking about as when we're talking about feedback, which brings us to our most recent and I think our final publication ever potentially on this topic, which is a guide to feedback and forensic mental health assessment that Sharon and I published very recently. The thing I'll say about this is when we first started out talking about this topic and first started talking about what our hopes were, was I had this vision. We were going to provide a definitive answer to the field about this question about whether or not you could provide feedback and how to do it and provide some standards. And what we realized over the years and doing this research, which I'll talk about in just a moment, is that there isn't a definitive answer to this. There's just a lot of clinical judgment and decision making. And our goal here was to help individuals think through this carefully about whether and when they should provide feedback. So this is our guide. So that word was very carefully chosen by the two of us about how to decide when and how to provide feedback. So this particular manuscript or article touches on our review of the literature, our review of the ethics code, but also we did some novel research here ourselves. And I use that word lightly, research, because what we did was we ended up doing 3 focus groups with experts in the field. So we went to two well-established forensic training sites. We had, we videotaped the focus group. We asked questions that were targeted about feedback and best practices that people had established, if they had established any, and those focus groups really we had forensic psychiatrists, forensic psychologists, we had a couple of postdocs, and everyone had their highest degree in the field. And we just had conversations with individuals in both those focus groups. We also did a 3rd focus group at a national conference with training directors across the country, where we asked the same kinds of questions. As thanks for everyone's participation, they got lunch. So essentially people gave up their time and energy and some money making to have these really interesting conversations. I think Sharon would agree with me that every single one of these conversations were interesting and had us thinking really hard about what people are doing and what they're training the new generation to do in terms of feedback. So we had about 28 people participate in this. Sharon and I took a grounded theory approach, and we analyzed all of the videos individually. We each initially came up with around 20 themes and then pared it down to about 15 themes each that we developed from these focus groups. So on our next slide, you'll see the 15 themes that we came up with, and we divided them into 2 different categories that we consider to be substantive and categories that we consider to be logistical. And so when we're talking about substance, I kind of think of it as content-related reasons as to why you would think about whether or not to give feedback. And logistical has to do with what is happening around the environment that might prevent you from providing feedback. So for example, safety considerations for the evaluators. So when I think about that, are there safety concerns? We'll talk about that a little bit further. I have highlighted a little bit, we have highlighted a little bit in red a couple themes that we just want to point out to you. As you'll see, I'm pointing, I realize on my screen and you cannot see my finger, but I'm pointing to theme number 3. So feedback typically prompted by an evaluee request versus standard practice. That was something we saw throughout all of our focus groups that people talked about, was that people often didn't have an established way in which they brought up feedback, but when an evaluee asked, which happened often, that's when they had to think in the moment about whether or not they would provide the person in front of them with some information. They also talked a lot about in these focus groups, the potential for feedback to create tension about evaluators' role. That's number 5. So people are thinking really critically about what could happen if you provide feedback to the person in front of you. Could that shift how that person thinks of you as an evaluated to more of a therapeutic kind of setting? It was also discussed that sometimes just small amounts of feedback, partial feedback, number 8 on this list, can play an important role in forensic evaluations. And number 9, providing feedback to someone other than the evaluee could provide a good opportunity for the evaluee to get the information that could be really beneficial for them. So providing it to a treatment provider, their attorney, for example, are places to provide that additional feedback. Something that also came up quite a bit that I thought was really interesting and I thought would come up more, because in my head, when I started this 10 years ago, the reason why I was not giving feedback was because the person in front of me was not the client. For some reason, that was what stuck out to me. And that did come up in these conversations. And it definitely was a theme that arose, but it wasn't the only theme that arose. As you can see, there's 15 here. So that notion of the court or another legal party as the client is a reason why people are considering not providing feedback, right? Because their feedback doesn't belong to the person in front of them. So that was one of the themes, but it ended up not being a big sticking point for at least anyone in the groups that we chatted with today. So as you can see, I'll give you a moment to take a look at the rest of the themes. Those are the ones I think we just wanted to highlight for you. Sharon, I think a lot of these we will be talking about in just a bit when we talk about our decision tree moving forward.
Yeah, so that's a good segue maybe, is that we took our review of the law and ethics and the literature and these really deeply fantastic conversations we had with people in the field as part of these focus groups, and tried to fold them all into a decision tree. So it's not as though, every theme on our previous slide is going to have its own special place in the decision tree, but we think all of those considerations are going to find a home here. So this was kind of the bulk of the project. We know this is hard to see. I just wanted to put it up here so you could kind of see what the whole thing looks like. And then we're going to break this down and walk through the different sections of our tree. But like Lizzie said, we have this kind of step 1, step 2 framework where you consider the law, then you consider the ethics. And then we have a set of considerations that we are considering under the headline of logistical preclusion, and then a kind of broader and maybe deeper set of considerations that we are addressing under the rubric of substantive preclusion, just like the themes that emerged from our focus groups. So no surprise, Step 1 is we're still going to send you to the law, with the full knowledge that often the law is not going to resolve this issue. But certainly look at whatever guiding framework you have for the evaluation you're doing, whether it's a statute that's authorizing the evaluation, a court order, a contract, and see if this question is addressed, If it is, you're going to fundamentally most likely do what the law requires. Based on our focus groups and conversations, this is most likely to take the form of a contract prohibiting you from providing feedback in things like an independent medical evaluation or child custody evaluation. Or you're going to, if you find some tension between the law and our ethical responsibilities and duties, then you will, follow our ethical considerations for resolving tensions like that. I know I said earlier that, most of the time law is not going to answer the question, but did want to just emphasize with a, brief example here that rereading those statutes, court orders, whatever they are that govern your evaluations can be useful. So this is the Virginia Code outlining the procedures for our quote unquote psychosexual evaluations after somebody has been convicted of a sexual offense. And here it says, upon completion of the examination, we are supposed to submit our report to a list of parties that you might expect, like the counsel for the defendant and the attorney for the Commonwealth. But there it says we're actually supposed to be submitting our report to the defendant themselves. That does not appear in other kind of comparable statutes outlining the process for competence to stand trial or criminal responsibility evaluations. But it does appear here. That does not, we don't think, answer the full question of whether you're providing feedback in the moment to the person, things that are beyond what's going to be outlined in your report. But it is a data point worth considering, and just a reminder to go back and reread some of those statutes that we all kind of take for granted and don't read line by line anymore, because there might be information in there, but it is a bit of a treasure hunt in this context. If the law does not answer your question, you're going to consider, of course, the ethical considerations. And so the first thing under this logistical preclusion rubric is thinking about whether you even have feedback to provide in that moment. Because clearly the ethics code and our specialty guidelines are giving us an out. And this is an inference, but reading into that, we might say they're probably in part giving us an out because we might not always have feedback to provide in the moment. If you've done reasonably complicated or maybe minimally complicated criminal responsibility evaluations, you know that you don't always have your impressions formed at the end of an interview, which might be the one point in time that you're actually seeing the defendant. Often our process is just not complete until we make those collateral calls, get in more records, look at testing results, or just sit and think about it for a little bit. So there might just be, right, without considering more substantive issues, there might just be logistical reasons that we don't have much to say to the person in the moment. And based on our read of the ethics code and specialty guidelines, that's okay. So one of the first ways to think about this is if you don't have feedback to provide in the moment, which you might not, and you might just have to explain that to the evaluee, thinking about whether there's an opportunity for feedback based on a host of kind of circumstantial factors, right? Do you have the time to do a feedback session? Is there going to be money allocated for that? Is this a case where you could actually bill for having a feedback session, and would that be appropriate? Or do you work in a setting where feedback would actually be pretty easy to implement, right? If you're a hospital evaluator and you have the opportunity to see the person pretty readily in the next day or the next week, logistically, you might be able to provide feedback. And so thinking through whether this is something that is worthy of time, is worthy of effort, thinking about whether it's something you can bill for, or if you are just working at your capacity and your capacity doesn't allow for that, that's okay, based on this kind of idea of logistical preclusion. If there is an opportunity for feedback, right, just like the circumstances might allow you to provide feedback, our next consideration is safety concerns, and I'll let Lizzie talk to you about that. Oh, I'm sorry, I forgot my animation. That's, tricky. This is just highlighting those factors I mentioned before, right? What kind of setting you're working in, whether, right, there's kind of financial compensation for taking the time to provide feedback.
And thinking about exactly as Sharon is saying, thinking about if you're inpatient, if it's a one-time evaluation versus if you're seeing the person repeatedly over 4 months, being paid is a real consideration that came up in all of our focus groups. That can be a consideration that people have. Can you set up another feedback session to go back? Can you be paid for that? Would you not be? But another very real question that should be considered and thought about is safety. So what we wanted to think about is the fact that the evaluees that you're sometimes working with have a violent history, and the information that you're providing someone in not exactly a therapeutic context can be really upsetting, and you're not providing the therapeutic environment for someone to necessarily hear the information they're going to be about to hear, right? Where we talk a lot about the separation between evaluators and therapists and being very careful about your role there. And so as a result, you might have some safety concerns before you provide this very serious feedback about perhaps a psycholegal question. It is important for us to note that violence is really a rarity in forensic evaluations. So we do not expect it to occur, but it can and should be a consideration that someone has in trying to make a decision about whether or not to provide feedback. So you might have idiographic factors about the individual that suggest they have a pretty severe history of violence, and that might be a consideration for you not to provide feedback in a certain setting, and that's fine. As we say, declining feedback is an appropriate route to take, but it might be, again, that it's just one piece of the puzzle that you're thinking about when you decide whether or not to provide feedback. And are there things that can be done to mitigate that risk, to make it so that there's less opportunity for a violent outburst if you suspect that one might occur? Could you set up the room in a certain way? Could you provide it with an intervention team nearby so that they know what's coming, so that person can be supported after you provide that information to them? So moving on about, in a kind of similar vein, thinking about safety is a little bit different. You're thinking about your safety, but you also need to be thinking about the person in front of you. And I think this goes back to my initial story about the harm that I was fearful that I had caused for the defendant that I had testified on. And so the question here becomes, could providing feedback cause psychological harm to the person in front of you? And yeah, we're talking about things that you would expect, like sadness or anger and anxiety. And is that reason enough to not provide feedback? Well, as you know, one of our duties as psychologists is do no harm, right? So thinking about that, we don't want to cause harm to the individual in front of us, but recognizing that they might hear it for the first time in a courtroom, and that might cause more harm. And Sharon and I did a little bit of a deep dive into HIPAA as well, to just give us some context about how another organization thinks about access to medical records. And what HIPAA says is that this doesn't quite count as medical records. So HIPAA doesn't truly apply in this setting. We're just using it as kind of an example, but people have the right to medical records. And there's this very small area in which you can choose not to provide medical records if there's real psychological harm that could occur. And so we use that kind of as context to think about psychological harm in forensic evaluations, and if we have the right to not provide feedback because of real severe psychological harm that we feel might occur. So it is a context that can be considered, but it also, this can be mitigated as well. And you can think about harm that could occur, again, in a more severe way if you don't provide feedback in the moment. I think all of this takes a lot of thought, and we sometimes go around in circles, but I think it's really worth noting that harm is a consideration that you could have in this situation here as well. We also want to mention spoiling. So this came up quite a bit in our focus groups as well, and something that Sharon and I talked about a lot. So the concept of spoiling is, if you were to provide feedback to the person in front of you, is there potential for the information that you provide to them, could that change how they respond in a courtroom or in future evaluations? So in other words, if you share with someone that, I'm going to use the example that they are competent to stand trial, for example, and they don't want to be found competent to stand trial, could they then purposely deteriorate, malinger, or present themselves in a different way in a future evaluation or in the courtroom themselves? So we thought carefully about how feedback might change the person's presentation, and how that might impact your findings at the end of the day. And in fact, I believe that, Sharon, you have a particular story about this that I thought would be quite helpful.
Yeah, so we talk about this idea of spoiling as often like the crux of the issue when you distill down a lot of our substantive concerns as forensic practitioners about providing feedback is that somehow it's going to compromise the integrity of our evaluation and therefore compromise our duty to whoever our client is. And certainly we don't want to take actions that somehow compromise our final product or the client who we have an obligation to. And so this comes up sometimes, right? If there is going to be some evaluation after yours, and this came up for a colleague who was requested to provide information following a risk assessment. And then it comes to light in the course of discussing the appropriateness, the pros and cons of providing feedback, that this person was about to go on and have a second evaluation about their risk as well. And there was real concern that giving this person, kind of arming them with information about things that psychologist A was concerned about in terms of their risk, were then, going to be used to change how they report, describe, discuss all of that information in the second evaluation. And so thinking about, I think the phrase that came up a lot is thinking about the downstream consequences of providing feedback. And certainly if there's the potential to affect the results of another evaluation of the same person in the same case, right? That's deeply problematic. And so thinking about when our work is actually complete, it's really not complete when we've written our report or come to our conclusions. It's complete when the proceedings have ended. And so could we be doing something that somehow interferes with the legal system or whomever it is, whomever the client is, getting as accurate a sense that they can get of this particular evaluee? Sometimes we don't know that there's going to be a second evaluation. My colleague certainly, did not know this at the beginning of that conversation, but we can reasonably anticipate this in a lot of situations. If you are doing a criminal responsibility evaluation, for example, and you're maybe going to opine that the person meets the standard for the insanity defense, a lot of states allow for a kind of prosecutor requested evaluation of the same issue. We know that in high stakes or high profile cases, subsequent evaluations are often going to be more likely. And so really thinking through the likelihood of second evaluations and the likelihood that any feedback you provide could somehow compromise their integrity. We thought through this with respect to three common types of evaluations, at least for folks working in the criminal context. So competence to stand trial, criminal responsibility, and risk assessment. And these, will also vary depending on the nature of the feedback that's on the table. If you're providing very basic feedback about the person's current clinical presentation or what their condition is in a competence evaluation, that could be pretty different, than the considerations for providing the same type of feedback in a criminal responsibility evaluation. We know that in competence, it's part of the process, Some degree of feedback is built into this because we're giving people feedback about their understanding of the basic legal system and court personnel. Of course, that's very different than providing feedback about the psycholegal issue, for example. And feedback also has the potential to be misleading for the reasons we talked about earlier, Our opinion, our reports are not the final word on the matter, and we certainly don't want to be misleading evaluees by, saying, for example, we think that you're competent to stand trial, if the person then goes to court and the court reaches a different conclusion.
What I found interesting, Sharon, not to interrupt, was in our focus groups, a theme that we heard, or not a theme, but something that we heard pretty regularly from our professionals was that people felt pretty comfortable regularly providing feedback and competence to stand trial evaluations, but not criminal responsibility evaluations. And it was often the case that people couldn't articulate the reasons behind that. And Sharon and I found it kind of our job to dig deep to try to figure out why people were saying that without a kind of deeper understanding of their rationale behind it, because they did know, or they did feel that they should do, and that was their practice to do, but they couldn't kind of grasp the reasons behind it. And that was, again, one of what we found our job was to do here.
Yeah. And a lot of it seemed to deal with, again, kind of compromising the integrity of the standard, right? Not wanting the idea of this kind of granular sense of how forensic mental health practitioners evaluate criminal responsibility, that information being more broadly disseminated in perhaps an unhelpful way. So there is this kind of gut instinct, I think, for many of us, but it's harder sometimes to articulate why. We know that in risk assessment, right, the R&R model really supports providing feedback about somebody's risk and engaging them in treatment. But we also know, as the earlier example kind of illustrated, that providing feedback could end up compromising a second evaluation. Of course, there are lots of other types of evaluations, and we have not thought through the kind of considerations or pros and cons of either of them, but are hoping that this like overall framework of logistical preclusion, substantive preclusion, and in particular, this idea of spoiling is still helpful in walking through the process. If you land after kind of walking through the decision tree, if you land in a place of potentially providing some kind of feedback that's been requested, this could be absolutely a way to respect the dignity and rights of the evaluee that you're sitting with. And as long as this isn't compromising other duties and responsibilities you have, we think it's worthy of consideration. It can benefit the evaluation as a whole. It can help rapport building. It can help, again, elicit useful information for us. But we, of course, have to be attentive to that boundary, right? We're not therapists. Our job in those contexts is not to cross the line and become therapists for the person we're evaluating. And so being mindful of that in the language that we're using and maybe explicit reminders about our role is going to be important. And of course, timing can be important too, right? If you're providing feedback after an evaluation is concluded, perhaps there's less opportunities for spoiling, but maybe you're eliciting really useful information you would have liked to include. And so thinking through that consideration as well.
And we also wanted to put out there, it's okay for you to decline feedback as we have put together in our decision tree. We just want you to be thoughtful ahead of time about it. And so we also wanted to stress to you that including in your notification of purpose, that you wouldn't be providing feedback is something that is clear in the ethics code, that this is a place that you can tell someone ahead of time what you will be doing and what information you will be giving them and not giving them. You might also find that partial feedback is appropriate. You might tell them about testing or some questions that you have about interventions that might be appropriate based on their history. But we encourage you to be upfront and clear and remind you that psychoeducation is your friend. You can help someone understand their story better by explaining concepts to them that they might not otherwise have had the opportunity to learn about had they not had this opportunity to have an evaluation with you. So with that said, that's a quite abbreviated decision tree for us, and we're happy to answer any questions you might have for us.
Well, thank you so much, Sharon and Lizzie, for going through all of that with us. This is an issue I've heard you talk about for years, and it continually comes up that as soon as it's brought up, people have that aha moment. And then, as you mentioned in your own origins of how this question came to you, people say that's a good question and then oftentimes don't know how to respond after that fact. So I really appreciate you putting all of this together for the audience and also the field in general, of course, and everything you've done in this arena. We do have a number of questions already. Of course, feel free to enter any more in the chat as you have them come up. The CEU links are in the chat box. Make sure those work for you. They do work, and if they're not working for you right now, make sure you save those for later. The link and your code right there, you can also scan as well. So one question that comes up is, this idea of, decisions to not provide feedback. And you had brought up the scenario of not providing feedback if it could cause potential harm. Has there been any discussions or considerations in the moment if you decide ultimately you're willing to give feedback, but then in the specific context there, your client, the person asks for feedback and you feel like it will ultimately harm them? So it's not in your it's not in your early disclosures because you're generally open to providing feedback. But in this particular case, you feel like feedback will cause harm. What challenges or what considerations have come up in order to how to address that in the room?
Sharon, I have an initial thought about it,
Yeah,
and I'd love
go for it.
your feelings from it. It's that this is not a one and done, go through the decision tree moment. It's a work in progress as you are doing your evaluation in real time. And so it's quite possible that your decision making might change from the start to the end of the evaluation. And that, based on our understanding of the ethics code and literature, seems quite appropriate if someone has to change their mind due to the circumstances in the moment. And I think that that would make perfect sense. Sharon, would you agree with that?
Yeah, and I think what often came up in these kind of sensitive situations where we're declining feedback because we're concerned about some kind of harm to the evaluee. I think that rubric or heading of partial feedback covers a lot,
Yes.
but sometimes that takes the form of, just like validating their experience, validating that they're working hard or being vulnerable or whatever it might be that's appropriate to the situation. And so, kind of pushing them off, right? Declining, but not taking, maybe giving them room for a soft landing and kind of validating the fact that they asked whatever they're doing in the evaluation that's been helpful to the process as a way of moving them off that topic. If you think, oh, this is just going to be kind of a mess if we go down this road.
Certainly, definitely appreciate that perspective. Thank you for that. Somebody brought up a scenario that's happened to them afterwards. I think you referenced, some of the challenges regarding spoiling assessment results. This person asked, what if attorneys give your assessment to the client and they have it in detention and want to discuss it with you at a later time? So after you've done your eval, now they're seeing your report. This person said this happened to them. They had the person had the evaluation in hand and was actually sharing it with other detainees. So thoughts on that?
Yeah, I at least can echo that I've been in similar circumstances and have colleagues who have found themselves in similar circumstances. Often, right? Well, I think that there are generally these questions about, oh, if the defendant in criminal proceedings is the evaluee, at what point is it appropriate to share the report with them? In some ways, right, we're sending reports often to their attorneys. If you take a step back, the attorney is really the agent of the person. And so it seems weird and paternalistic maybe to prevent them from seeing the reports. On the other hand, right, when they do get the reports and those reports are circulated in correctional settings or wherever, then maybe we do have concerns. And I think the options here are more flexible if, in fact, the proceedings are over. I think if the proceedings are not over, that might warrant a more in-depth conversation with the attorney about kind of the appropriate way to handle that potentially. If they're over and done, I think it's up to the individual to decide if there's just logistical reasons that they don't want to get into this. And if so, conveying through the attorney that there's just no more contact, after the process is over. And if you find yourself in a position where you think some degree of feedback might be helpful, whether that's, about the person's clinical condition or something like that, then making arrangements, again, probably through the attorney, to do that is, I think, on the table at least. But again, if you're envisioning or seeing this as a person who might come through the system again, we know that's incredibly common. Thinking about not compromising the current evaluation, but evaluations down the line. And so arming them with a lot of psycholegal information might not be so helpful. Arming them with perhaps, here's how I see your clinical condition could be perhaps more relevant and less likely to interfere.
And I'll add to that, Sharon. It makes me think about one of the things that we have talked about a lot, that our process behind this has shown us that you can provide feedback. You just don't have to provide feedback. And so if you're aiming to do your due diligence and letting someone know in the notification process at the beginning, or if there's reasons you have to change your mind later on, you're within your right as a forensic psychologist not to end up providing feedback at the end of the day. We just wanted to provide some helpful ways of thinking about, if you want to, or if you can, and here's our what the considerations for doing that.
Certainly, and thank you so much for that reassurance there. Somebody asked that in context to the idea that feedback could potentially be misleading, someone asked, given that the judge ultimately makes the determination of competency, is it the idea that wouldn't providing feedback be uncommon in a competency evaluation there?
Fundamentally, that was the concern raised by a lot of our focus group participants, is just that we're not the last word on really any of this for the most part. And so just being really mindful of that role and not, again, like misleading somebody to think that just because I say you're competent or incompetent, that's the way the court proceedings are going to go. At the same time, people were also pretty straightforward that they're more likely to provide feedback in competence evaluations, and citing that kind of high degree of agreement between judges and evaluators most of the time. But there's still that kind of caution out there. And I think that applies, kind of across the board too.
This was a common debate we saw, I think, in every single focus group we did about the fact that we are not the ultimate decision makers here. And so could it, if this isn't the end of the process, do we even have an ability to provide feedback about the ultimate legal question? And at the heart of it, people essentially ultimately decided that we could, but there was still a lot of debate about it. And I understood that debate because I feel that debate a lot.
And I'll maybe just add here, sorry, that psychoeducation piece that Lizzie mentioned in declining feedback, that came up a lot here, specifically in the version of telling folks that, hey, most people are either found competent or eventually restored to competence, or it's rare for people to meet criteria for the insanity defense. It's an incredibly high bar. A lot of folks thought that providing that kind of baseline information through psychoeducation was a helpful way to sometimes address the issue without providing specific feedback about that person's case.
Wonderful. Any information regarding your thoughts on giving feedback to individuals who are in an inpatient forensic evaluation and competency to stand trial treatment regarding poor effort or suspected malingering if the attempt is to have them engage more in the treatment and evaluation process?
This came up frequently, absolutely, and was a context where, again, like pretty readily when we start talking to evaluators, they're able to say like, oh, effort, malingering, response style issues, those are definitely an avenue where providing some type of feedback can be really useful as long as it's right, like not immediately after one of those effort tests or something like that, that would compromise the usefulness and validity of the test. So this came up, I think, frequently as an area where there was more consensus around doing something to provide feedback. There was a lot of variability in specifically how evaluators went about doing that. And this is kind of consistent with that Brodsky and Goldenson second level interpretive feedback about like, hey, is it possible that there are times, and maybe there are even times with me, that you want to come across as more ill than you actually are, and exploring it that way in a pretty direct way. But yeah, can be an uncomfortable conversation. And there was a lot of variability, I think, in how willing people were to address that. But still some consensus around addressing it in some way could be really useful.
Well, we are short on time. I do want to make sure for everyone here, given the helpful information and the large reaction here too. Someone asked about the one of the papers that you had talked about. The recent guide to feedback in forensic mental health assessment, I believe, is in the Professional Psychology Research and Practice Journal. If you want to look it up there. And for anybody that's attending the American Psychology Law Society conference in March, Drs. Kelley and Foster will be doing a pre-conference, a broader, longer, in-depth talk about this exact issue. So thank you so much, Sharon and Lizzie, for sharing all of this with us today. It's a really helpful thing for us to be considering, and I find in my own practice, my brain has often stopped in terms of like how to actually do this. And these trees, these guidance, and also the reassurance in terms of the limits of what we actually have to do versus don't have to do is reassuring in practice. This has been very helpful, and I very much appreciate it. So that wraps up this week's University of New Mexico Law and Mental Health series. We hope to see you next week when Dr. Chris Lloyd will be discussing issues in forensic supervision. So until then, have a fantastic rest of the week and take care.
Thank you.
Thank you.